Hello everybody, it's Melanie Shapiro. I am so excited about a new case that just came out of the First Circuit that I want to talk about today. It's called Pineda Maldonado versus Garland, and it came out 2 days ago on Wednesday, January 24th, 2024, and there are 3 reasons why this case is important. The first one is that this discusses the issue of persecution and torture, and it makes some really important findings on that. And then the second reason is that it expands on this issue of people who are facing gang-based violence and threats. And this case takes place in El Salvador. And I'm going to talk about why this case expands on another good case that was issued last year. And the third reason that this is important is that it clarifies some issues about family membership as a particular social group for asylum cases, and I'm going to discuss that. Now, for those of you joining in and you don't know about me, I am an immigration lawyer. I am based in Massachusetts. I specialize in asylum law and other forms of humanitarian relief. I also teach at a law school where I teach issues related to immigration and also federal litigation. And so I am super excited about this case, and I'm going to just start telling you why. So for a little bit about the background of this case, in this situation, the person who applied for asylum, who is Ricardo Jose Pineda Maldonado, who is the petitioner in the First Circuit Court of Appeals, he filed for asylum and withholding of removal and protection under the Convention Against Torture. Here, there are some people referred to as cattle thieves who murdered his father, were responsible for his death, and his father owed a debt to them. Now, they came after Jose, Mr. Pineda Maldonado, and they attacked him one time, and they threatened him with death threats. Another instance, the petitioner here, he was beaten up by the police, which was a couple of months after he was threatened by the cattle thieves. And then he also saw another time that the cattle thieves were talking to the police, so it seemed like they had some sort of relationship. And he fled El Salvador after all of this occurred because he feared for his life. Now, below in immigration court, the judge decided that these imminent threats, these threats that he received did not amount to torture and also did not amount to past persecution. The judge also decided that there was not a connection between the harm that he suffered and the group that he claimed to be part of, a family member of his father, so his immediate family member. For asylum, you have to show that somebody has suffered past persecution or has a well-founded fear of future persecution, that the harm that they suffered amounts to persecution if they suffered past persecution, and that there is a connection between the harm that they suffered and who they are. There's a few protected grounds here: race, religion, nationality, membership in a particular social group, and political opinion. Most of the asylum cases are through this lens of particular social group. And there is a lot of case law, it's always changing regarding the particular social groups. So we have that. And then you also have to show that the harm they suffered, besides being on account of this protected group, that the government is unwilling or unable to protect them. And, you know, those are the essential elements that you have to prove for asylum. In this situation, when the cattle thieves did attack him, and we're looking at the issue of whether the government is unable or unwilling to protect him, one thing that's really interesting here is that he saw the cattle thieves talking to the police about, so he saw them kind of cooperating with one another. The police did nothing to protect him, and in a previous case called HHV Garland, which was issued out of the First Circuit last year, one exciting thing here is that the First Circuit said that a certain organized criminal groups could be viewed as de facto government agencies. So a group that the government is unable to control or doesn't want to control. And you think about some countries in Central America that are essentially, the gangs have a lot of power, like in El Salvador, in Guatemala, in Honduras. So that was a wonderful decision. And in this Pineda Maldonado case, the government does discuss, or the First Circuit does discuss the HHV Garland case, and says specifically the IJ quoting, which is the immigration judge, quoting the HHV Garland case, failed to articulate her reasoning on this issue with sufficient particularity and clarity to permit us to infer that the factual or legal basis for that determination. Even though it doesn't really get into the whole issue of the government being unable or unwilling, or whether the cattle thieves were a de facto government agency, it is a good thing that the circuit did cite to that particular case. So one of the issues below with the opinion with the IJ is that the IJ just kind of made this blanket finding about the particular social group, but specifically about the issue of the death threats. And one of the issues that the First Circuit had is that the judge did not have reasons that were, particular and sufficient to make that determination. And then what happened is, when this case was appealed to the BIA, the Board of Immigration Appeals, the BIA just basically said, all right, whatever the judge said, and didn't provide any sort of independent analysis and deferred to the immigration judge's opinion. So that was a problem here. What's interesting is, I was saying about the de facto government agencies, this case, HHV Garland, is applicable in many other situations. For example, I have asylum cases from Pakistan or Afghanistan where you can look at the Taliban as a de facto government agency, that the government is not able to control them, that they are essentially running the country. So that was a very important decision. I'm happy to see that that case was quoted in this opinion. The other thing that's kind of ridiculous here is the IJ saying that these threats didn't amount to torture when looking at the CAT claim, the Convention Against Torture claim, because death threats have long been recognized as a form of torture. And even there's prior case law that says that persecution can be a death threat made in person, if possibly with a weapon that the person believes that will be carried out. So there are various situations and cases that address threats and whether or not those amount to the level of persecution. And so in this situation, there is a discussion about this, that with the torture, basically the IJ was incorrect about the findings of the death threats not amounting to torture, and therefore also incorrect about the death threats rising to the level of persecution. The case is remanded back down so that there could be a determination that is made, is reasoned on the issue here. So the court says, upon remand, therefore, we expect that if there is a finding that the threats the petitioner received do not amount to torture, it will be accompanied by meaningful reasoning. So that's very interesting. And then they also say, but just as threats of death may cause torture when they are threats of imminent death, threats of death constitute persecution when they are of that unusual kind. So the judge, the circuit court is saying, listen, if this holds water for torture, it certainly holds water for persecution and should be considered meaningfully. Now, the other thing that I wanted to point out and go over is this whole issue of family as a particular social group. There was a lot of, I guess you could say, drama during the Trump administration with a case called Matter of LEA that Attorney General Sessions had referred to himself, and basically kind of eviscerating family membership as a particular social group. And after a couple iterations of that, family membership was once again stronger as a particular social group. Now, part of what the immigration judge was saying here is that, this is just kind of a personal vendetta. They thought that maybe this guy was going to be retaliating against the cattle thieves because they had killed his father, or that the cattle thieves were just going after him because his father owed a debt and they're trying to recover that. But the First Circuit says, we have been clear that the mere fact that a family receives threats as a family unit without more does not convert a non-protected criminal motivation into persecution on the basis of family connection. But they raise the issue, well, what is the more? What more must they prove? What does that entail? And they clarify, we have explained that for persecution to have been on account of family membership, the reason for the persecution cannot be incidental, tangential, superficial, or subordinate to another reason for the harm. And that rather, family membership must be the root of the persecution, and that's the key. So if somebody has been persecuted, it just has to be one central reason. There could be various protected grounds for which the person has been persecuted, but if you're proposing one particular social group, it only has to be one central reason, not the only reason. And that's clarified here. And that, so they say, that does not mean, however, that such membership must have been the sole reason for the persecution. Family membership need only qualify as one central reason for the harm. Then the court continues discussing that some, and then later on, the court says, when considering this, as I had mentioned, that the IJ and below, they argue that the alleged persecutors' fear of reprisals is what the immigration judge had said is that was the motivation, not this nexus that's needed about family membership. And however, when looking at the root cause, the court concludes that yes, this was the root of the persecution, that it isn't just because they're trying to collect money, it's because they're looking at this person because of his relationship to his father. Otherwise, they wouldn't have been going after him because, and this person, the petitioner here, was on the farm day to day in the operations, had witnessed interactions with the cattle thieves. So that's an additional connection here with the family membership. And they compare it to another case that was out of the 11th Circuit. And in this case, the court reasoned it was a situation where a cartel had targeted someone to pay back a debt that the father-in-law had owed to the cartel. The court reasoned there that it was impossible to disentangle the applicant's family status from the cartel's pecuniary motives because of an absent the familial relationship. The cartel would never have hunted the applicant down. And then you go further and say, for the reasons we have given, it is impossible here as well to disentangle the family relationship. So the court also mentions that there is a split among the circuits, that the animus towards the protected ground must motivate the persecution for the applicant to be eligible for asylum. And this is kind of circular when you think about the family membership. So it talks a little bit about that, but the court concludes, but they don't agree with those circuits, and they said the asylum statute does not say anything to suggest that animus towards a particular social group is required for an applicant to be eligible for asylum, as is used as the phrase on account of. That was a good clarification there. And when talking about LEA, it says only the animus is a sufficient reason to find that persecution is on account of family membership, not that it is a necessary one. So then they conclude basically that they construe it in a manner that accords with the notion that an asylum applicant must show that they have a well-founded fear of persecution that is based on something that is beyond the power of an individual to change. So in this situation, Pineda Maldonado, there's no ability for him to change that he is the son of his father, and that's kind of where it wraps up. As I said, I'm really excited about this case. I think that it's going to be really good for cases going forward. I have some cases right now that I am definitely going to be using this one for. For example, I have a case of a woman from Guatemala whose husband was murdered by an extortionist, and after that she was targeted by them and received death threats, and she had to flee Guatemala. And there's a number of other cases that this case will apply to. So I was really excited yesterday when I finally had the opportunity to sit down and dive into this opinion, and I'm happy to share it with all of you. So again, I'm Melanie Shapiro. Follow me on YouTube and subscribe to the channel. I'll be posting a lot of updates about new cases coming out, any updates about immigration. You can go ahead and like it, share it with people, and if you are interested in learning more, you can book a consultation on my website or just reach out to me. Thank you. Take care.